Hello, everyone, and thank you for attending this very important presentation. Today, we're talking about President Trump's December 8th, 2025 executive order on cannabis rescheduling. This presentation explains what the executive order actually does, what it does not do, how the Schedule 3 process really works, and what the most likely implications are for taxation, banking, insurance, hemp, and cannabis operators. And really, today, my goal is clarity and not hype, what we've seen actually in the headlines. Just to introduce myself, I'm David Kay, a certified public accountant, a certified management accountant, and certified fraud examiner, and the founder of Proactive Tax Planners, where we focus exclusively on accounting, tax, and advisory services for the cannabis industry. I've spent more than 35 years helping owner-led businesses strengthen their accounting systems, internal controls, and tax strategies. I've dedicated my work specifically to the cannabis sector, diving deep into the practical application of Internal Revenue Code 280E and Section 471 to help cultivators, manufacturers, and dispensaries stay compliant while protecting profitability. My mission is simple: to help cannabis operators move from reactive bookkeeping to proactive financial strategy, building clean, defensible books that not only minimize taxes but also increase enterprise value when it's time to raise capital or prepare for sale. I am very excited today to walk you through today's topic and share what I've learned from analyzing the rules, case law, and real-world operator scenarios that define this rapidly evolving space. As I mentioned earlier, I'm a CPA, but not your CPA. So before we jump into the presentation, I must show you this disclaimer stating that this presentation is provided for educational and informational purposes only and should not be construed as tax advice. Is general guidance and might not apply to your individual circumstances, so you should not take any action based on this information without first consulting a qualified tax professional. Now that that's out of the way, let's jump into the meat of the presentation. So for today's presentation, we'll go over, firstly, the executive order, what it actually does. Then we'll also talk about what the executive order does not do. We'll talk about why this is happening now, what Schedule 3 rulemaking really means, impact on 280E banking and insurance. We'll also talk about what are realistic timelines for all this to play out. And then I'll discuss some final takeaways from what we've gone over. On December 18th, 2025, President Trump signed the executive order titled Increasing Medical Marijuana and Cannabidiol Research. It does not legalize weed. What it does is instruct the Attorney General, Pam Bondi, to take all necessary steps to complete the already in progress formal rulemaking to move marijuana from Schedule 1 to Schedule 3 under the Controlled Substances Act, and to do so, quote unquote, in the most expeditious manner. It also broadens the conversation between marijuana to include CBD and hemp-derived cannabinoids, directing the administration to work with Congress on definitions and a regulatory framework and to develop research model that uses real-world evidence. Understanding what this executive order doesn't accomplish is just as important as understanding what it does. This is not a sweeping legalization order that fundamentally transforms the federal legal landscape overnight. It does not federally legalize recreational cannabis. It does not override state law. It does not instantly open banking, and it does not make dispensary products FDA approved. Again, this is not a legalization order. It does not authorize interstate commerce, does not turn dispensaries into pharmacies, and does not remove all federal risk. What it does actually is it accelerates a regulatory classification decision. Nothing more, nothing less. So the process started well before the executive order. The order is best understood as a political accelerant and not a reset of the process. The science review has already happened. The proposal already exists. The bottleneck has been actually in procedure, not in any evidence. So really the key points here is in 2022, the White House requested scientific and medical evaluation review. In 2023, the U.S. Department of Health and Human Services recommended Schedule 3. In 2024, the DOJ, the Department of Justice, and the DEA issued proposed rule. And in 2025, in January 2025, the hearing was delayed. So this order that Trump just gave, actually, it applies pressure to move that process on expeditiously that has already been stalled. So rescheduling is administrative law. It's not a press release. The DEA must build a formal evidentiary record, respond to comments, conduct a hearing if requested, and then issue a final rule published in the Federal Register. And even after that, lawsuits are still possible. So really, the key points here is that this process is governed by the Controlled Substances Act. It requires notice, record, and opportunity for hearing. It ends with a final rule plus an effective date. And as I mentioned before, it's subject to court challenges, which can be either few or numerous. So let's walk through what has actually been completed in the federal cannabis rescheduling process and what remains to be done. So completed at this point, the scientific and medical evaluation has been completed. This first phase is done at this point. The Department of Health and Human Services, or HHS, conducted the required scientific and medical evaluation under the Controlled Substances Act. This review focuses strictly on medical use, safety, abuse potential, and the state of scientific evidence, not politics or state legalization. So based on that analysis, HHS formally recommended moving cannabis to Schedule 3. Most importantly, that recommendation is final and binding from a medical and scientific standpoint. So the DEA, the Drug Enforcement Administration, is not permitted to second guess or override HHS's medical conclusions. From a science and medicine perspective, this step is done. The next step that's completed is where the DOJ and the DEA, the proposed rule was issued. So the Department of Justice and the DEA issued a notice of proposed rulemaking, officially proposing to move marijuana from Schedule 1 to Schedule 3. That proposed rule was published in the Federal Register, which is the legal trigger that opens the rulemaking process to public participation. Again, this step is fully completed. So then the next step that's completed, public notice and comment. Once the proposed rule was published, the process entered in the public notice and comment phase, and during this period, tens of thousands of public comments were submitted by industry operators, medical professionals, researchers, advocacy groups, state and local stakeholders. So the comment window is now closed. So legally, the DEA is allowed to rely on this written record when finalizing the rule. There is no requirement that comments be reopened unless the agency materially changes the proposal. So again, this phase is completed. So now the next step that's actually been substantially completed is the evidentiary record. So where we're right now is in this phase, and this is mostly complete, but again, not entirely finished. The evidentiary record already includes written public comments, scientific and medical studies, internal agency analysis, formal submissions from stakeholders, which I mentioned before. But what has not yet occurred is live hearing testimony to supplement that written record. So that does not invalidate the process to date, but it does mean the record has not yet been fully closed procedurally. So once the hearings resume and testimony is added, the evidentiary record can be finalized, allowing the DEA to move toward a final rule. This is the stage where the rescheduling process is technically in progress, but also where it is currently stalled. A formal administrative hearing was scheduled as part of the DEA's rulemaking process. This hearing is meant to supplement the written evidentiary record with live testimony, questioning, and cross-examination. However, on January 13th of 2025, almost a year ago, the administrative law judge, John Mulrooney II, overseeing the matter, stayed the hearing. In other words, it basically put it on pause. That stay was issued because of a procedural appeal filed mid-process, known as what is referred to as an interlocutory appeal. This type of appeal doesn't challenge the science or the substance of rescheduling, it challenges process and procedure. So here's the important distinction. Legally, the hearing process has begun, but practically, the hearing has not actually occurred. So there's been no testimony taken, no witnesses have appeared, no cross-examination has happened. So while the process has started on paper, it has not really advanced in substance. So once the stay is lifted, this step must restart, allowing live testimony, questioning of evidence, completion of the evidentiary record. And until that happens, the DEA, under the Department of Justice, the DOJ, cannot move to a final rule. And this is really why the hearing phase is currently the single biggest bottleneck in the entire rescheduling timeline. The delay is not about whether cannabis qualifies for Schedule 3, it's about procedural mechanics and not medical judgment. We've discussed so far sets the table, but these next steps are the ones that have not yet started and cannot occur until the hearing bottleneck is actually cleared. So this phase, post-hearing findings and recommended decision. Once the administrative hearing actually occurs, the administrative law judge has to do several critical things. First, the judge must weigh all of the evidence, including what I mentioned before, written submissions, scientific studies, live testimony, cross-examination from the hearing. Then secondly, the judge makes a formal factual findings, essentially deciding what the record supports and what it does not. So then finally, the judge issues a recommended decision on whether rescheduling should proceed as proposed. But the really important point here is that this recommendation is influential, but it's not final. So then when we move on to the DEA administrative review, after the judge issues a recommendation, the process moves to the DEA administrator. And at this phase, the administrator reviews the entire administrative record, the judge's factual findings, the recommended decision, and the administrator then decides whether to adopt the recommendation, modify it, or reject it. This is the agency's final internal decision point. Then expected is a final rule is then issued and published in the Federal Register. So if the administrator approves moving forward, the DEA issues a final rule, which is then published in the Federal Register. And this publication includes an effective date for the ruling. And this moment is critical. This is really when rescheduling becomes legally real. So until the final rule is published and effective, cannabis is not rescheduled for federal law purposes. Tax law, enforcement posture, and compliance rules do not change. Everything before this is process, and this is where the switch actually gets flipped. But then there's one thing that really has to be identified here is that there's possible post-rule litigation window. So this could be APA challenges. So after the final rule is issued, a litigation window opens under the Administrative Procedure Act. And at that point, lawsuits may be filed challenging the rule, and courts may allow the rule to take effect while litigation proceeds, stay implementation, or remand the rule back to the agency for further explanation. So importantly, litigation does not automatically stop rescheduling, but it does introduce a certain amount of uncertainty and timing risk. Even after the final rule is published, the process is not completely immune from challenge. This is where the APA comes into play. So under the APA, and I'm kind of restating what I mentioned before, once the DEA issues a final rule, interested parties have 60 days to file a lawsuit challenging that rule in federal court. These challenges can be procedural or substantive in nature. The procedural challenges argue that the DEA may have failed to follow required rulemaking steps. Perhaps they did not adequately respond to significant public comments, or maybe the DEA cut corners in the hearing or evidentiary process. And substantive challenges argue that the agency possibly may have ignored key evidence, reached conclusions not supported by the record, or acted in an arbitrary or capricious manner under administrative standards. So this is really the primary legal risk to timing, not to the underlying science behind cannabis. So importantly, any interested party, including advocacy groups, industry participants, or state level actors, can bring an APA challenge. And while filing a lawsuit does not automatically stop rescheduling, courts do have the authority to allow the rule to take effect while litigation proceeds, issue a stay, temporarily pausing the implementation, or remand the rule back to the agency for further explanation. I kind of mentioned this earlier before. So again, if a court grants a stay, implementation can be delayed months or even years, depending on how long the litigation lasts. So the key takeaway is this: the final rule is the moment rescheduling becomes legally real. The APA litigation window, however, is the moment when timing risk re-enters the picture. And that's why understanding that the APA is critical, not because it reverses the science, but because it can slow the clock down. So this slide is really about setting realistic expectations around timing. So even in a best case optimistic scenario where the procedural appeals resolve quickly, the hearing restarts without further delays, all parties cooperate, and no one files a lawsuit challenging the final rule, rescheduling still takes months once the administrative process restarts. And again, as of this date, early January, that process has not restarted yet. So again, that's because the remaining steps are not symbolic. They involve restarting and completing the formal hearing, issuing post-hearing findings, internal agency review, drafting and publishing a final rule with an effective date. So there is no credible immediate scenario under administrative law. So anyone suggesting otherwise is either misunderstanding the process or oversimplifying it. So more realistically, the expectation should be that at least one legal challenge is filed after the final rule is issued. I think that's reasonable to assume that. And that challenge would fall under the Administrative Procedures Act, and while it does not automatically stop rescheduling, it reintroduces timing risk. So depending on whether a court grants a stay, how quickly briefing and hearing proceeds, and whether appeals are involved, that litigation could possibly add another 6 to 18 months to the timeline. This slide addresses some of the most common misconceptions around rescheduling and tax relief. So first, it's critical to understand the baseline rule that an executive order does not change the Internal Revenue Code. Only United States Congress has the authority to amend tax law. The executive branch can start the rescheduling process and the DEA can finalize it, but neither can rewrite the tax code. So again, we talked about earlier about possible retroactive relief. It is possible, but absent a specific congressional action providing retroactive relief, we expect 280E relief will be prospective only, beginning on the effective date of the DEA's final rule. The IRS cannot retroactively waive 280E without statutory authorization, regardless of rescheduling. So, and here's another good thing to understand. 280E is tied to the drug's federal schedule. It's not tied to whether a state labels the sale as medical or recreational. So the good thing is that 280 relief, when it comes, would apply to both medical and recreational cannabis. Executive order emphasizes medical use, and that framing matters for why rescheduling is justified. However, under federal law, drug rescheduling or scheduling does not create separate classifications for medical versus recreational versions of the same substance, which I mentioned in the previous slide. So there is no such thing federally as medical marijuana Schedule 3 and recreational marijuana Schedule 1. It's one substance, one schedule. However, adult use still remains problematic, and that said, adult use cannabis does not suddenly become federally lawful commerce simply because marijuana moves to Schedule 3. And why is that? It's because adult use sales lack a recognized medical justification under federal law. Even at Schedule 3, the federal framework assumes distribution occurs pursuant to medical use within a regulated, justified context. Adult use programs exist entirely because of state law, not a federal authorization. So really, federal enforcement is discretionary, it's not automatic. And as a result, the federal government's posture towards state-compliant adult use programs really remains discretionary, policy-driven, and subject to change. There is really no automatic federal blessing for adult use commerce, even after rescheduling. So historically, non-enforcement has been driven by DOJ enforcement priorities, budget constraints, political and policy decisions, and not really by a statutory right to operate. This slide clears up, hopefully, another major misconception we hear all the time. So clinical trials are not required for rescheduling. So first and foremost, clinical trials are not a prerequisite to rescheduling. So under the Controlled Substances Act, the DEA can reschedule a substance based on existing medical and scientific evidence, state medical program experience, patterns of use, safety and abuse potential, and really that is exactly what occurred here. Rescheduling is a regulatory classification, not a drug approval process. However, where clinical trials are required, and this is a critical distinction, full clinical trials are required for FDA-approved pharmaceutical cannabis products. So if a company wants a specific medical indication, a defined dosage, a federally approved drug label, then it must go through the FDA's standard drug approval pathway, including rigorous clinical trials. So rescheduling alone does not satisfy those requirements. And so, what rescheduling does not do, it does not convert dispensary inventory into federally approved medicine. It does not transform dispensaries into federally regulated pharmacies. It does not change the fundamental state-based retail model, and does not make state legal cannabis products. They really still remain state regulated products and not FDA approved drugs. So that said, stage 3 dramatically lowers regulatory barriers. It makes serious medical research feasible at scale for the first time by reducing registration and compliance hurdles, allowing easier access for researchers, and enabling broader institutional participation. And this is why rescheduling is best viewed as a door opener, not the finish line for pharmaceutical grade cannabis. Is about separating real improvement from wishful thinking when it comes to banking. So rescheduling cannabis to Schedule 3 meaningfully reduces the stigma and perceived federal risk associated with the industry. So for banks, that matters. It signals that the federal government now recognizes accepted medical use, lower abuse potential, reduced enforcement posture around the substance itself, and that alone makes internal risk discussion easier. So who is most likely to move first? So as a result, some financial institutions, especially credit unions, community and regional banks, may become more willing to open operating accounts, provide basic treasury services, expand lending and cash management offerings. These institutions already tend to be closer to local markets and more comfortable with relationship-based risk assessment. However, Schedule 3 does not legalize the proceeds of adult use cannabis sales at the federal level. That distinction is crucial. So even if the substance itself is Schedule 3, banks are still being asked to accept deposits derived from commerce that remains federally problematic. So the legal risk shifts, but it does not disappear. So because of that, large national banks and their regulators are expected to remain cautious, and their hesitation is really driven less by the drug schedule and more by anti-money laundering exposure or the Bank Secrecy Act compliance or ongoing suspicious activity report obligations, and how federal banking regulators interpret cannabis-related risks. So those frameworks do not automatically change with rescheduling. Is about expectations. So rescheduling absolutely influences how institutions think about cannabis, but changes in insurance, employment, and safety regulation move much more slowly than tax or criminal classification. These areas are actually driven less by scheduling and more by legal precedent, actuarial and claims data, workplace safety and liability concerns. Scheduling alone does not flip a switch. So like for insurance coverage. So from an insurance perspective, the medical framing helps, particularly when cannabis is discussed as something recommended or prescribed by a physician. That framing can open conversations around workers' compensation, health coverage discussions, professional liability considerations. However, insurers remain cautious. So absent a FDA-approved cannabis product supported by clinical trial, most insurers are reluctant to treat cannabis like a conventional prescription drug or broadly covered products sold through dispensaries. So while the dialogue improves, coverage expansion is incremental and not immediate. So also when we talk about employment policies, rescheduling also does not override employer discretion. So even if cannabis is Schedule 3, becomes Schedule 3, drug-free workplace policies remain lawful. Pre-employment drug screening remains common. Termination for positive cannabis tests remain legal in most jurisdictions, and employers continue to prioritize productivity, safety, liability protection. Schedule 3 does not create a federal employment right to use cannabis. And also with federal safety rules. So the federal safety regimes are largely unaffected by rescheduling alone. So rules governing DOT drug testing, federal contractor compliance, safety sensitive positions, they really remain unchanged unless those agencies separately revise their regulations. In safety critical roles, cannabis remains treated as a disqualifying substance regardless of schedule. This slide is intentionally separate from marijuana rescheduling because the executive order is doing two different things at the same time. First, it explicitly acknowledges the regulatory chaos in the hemp-derived cannabinoid market that has developed since the 2018 Farm Bill. Products such as Delta 8 THC, Delta 10 THC, THC 0, and other semi-synthetic or chemically modified cannabinoids have entered the market by relying on the Farm Bill's focus on Delta 9 THC concentration rather than on total intoxicating effect or method of production. So really, as a result, we now have a national marketplace where intoxicating products are being sold outside of state cannabis regulatory systems, often with no or little labeling consistency, no standardized dosing, and minimal age or safety controls. And this has created concern across federal agencies, states' poison control centers, and medical professionals. So the executive order does not legalize or endorse these products. Instead, it attempts to get ahead of the next regulatory wave by directing federal agencies to build a research-driven and medically defensible framework for CBD and hemp-driven cannabinoids, particularly non-intoxicating or therapeutically oriented products, before Congress or regulators impose sweeping restrictions that could eliminate large portions of the market. This slide addresses a point that often gets overlooked in public discussions. So higher federal legitimacy does not mean lighter oversight. It usually means the opposite. So as cannabis businesses move towards Schedule 3 status and the potential elimination of 280E, the industry actually begins to look less like an enforcement outlier and more like a regulated manufacturing and distribution sector. That shift invites greater scrutiny, not less. So regulators, lenders, insurance, and the IRS all tend to raise their expectations when an industry becomes more financially material and more legally integrated into the broader economy. One immediate consequence is more sophisticated audits and due diligence. So financial statements will be examined with a higher level of rigor, particularly around revenue recognition, cost allocation, capitalization policies, and internal controls. Inventory tracking becomes especially critical because inventory is the bridge between tax compliance, cost accounting, and financial reporting. Poor inventory records that may have been tolerated in a cash-constrained 280E burn environment are far less acceptable once deductions are allowed and margins expand. From a tax perspective and for cultivators, cost accounting and capitalization rules move front and center. The IRS is likely to focus closely on how costs are classified, capitalized into inventory, or expensed, particularly during the transition period when Schedule 3 takes effect. So batch level documentation, production records, labor allocations, and overhead absorption are no longer nice to haves. They become audit reliant evidence. For manufacturers and processors, expectations rise even further. So as cannabis moves closer to the pharmaceutical and regulated manufacturing world, there will be increased pressure to adopt good manufacturing practice style controls, even if not formally mandated at first. So that includes standardized extraction protocols, documented quality systems, repeatable batch processes, and rigorous testing and traceability. So over time, operators who align their processes with pharmaceutical grade quality controls will be better positioned for partnerships, investment, and regulatory resilience. This also opens the door to research partners and clinical trial participation. So for manufacturers with the operational discipline to meet documentation and quality standards, participation in research initiatives become a strategic opportunity rather than a compliance burden. Now for dispensaries, the picture is different. Schedule 3 does not change the federal legal status of retail cannabis sales. Dispensaries remain state licensed businesses operating in a federally constrained environment. Banking may improve at the margins, but compliance complexity actually increases during the transition period, particularly around tax reporting, documentation, and explain the ongoing distinction between federal and state law to consumers, landlords, and financial partners. So really the overarching message is this: legitimacy actually raises the bar. Operators who treat Schedule 3 and 280E relief as an opportunity to professionalize their systems, controls, and documentation will benefit. Those who assume reduced scrutiny may find themselves exposed just as the industry becomes more visible and more financially consequential. Even if Internal Revenue Code 280E is relaxed or repealed, which in effect lowers effective tax rates, operators may not keep most of that benefit because competition forces prices down, passing the savings on to consumers instead of owners. So really how this plays out in cannabis, so what 280E relief does in theory, if 280E goes away, federal tax expense drops, after-tax cash flow improves, businesses appear more profitable on paper. Really on paper, margins should expand. But what actually happens in competitive markets, so cannabis is already oversupplied in many states, highly price sensitive, fragmented with low switching costs. So when operators suddenly have lower tax costs, they face pressure to cut prices to gain volume, match competitors who cut prices first, offer promotions to move inventory faster, but that means that the tax savings actually shows up as lower retail prices, not higher owner profits. So really, who wins versus who loses? So the consumers usually experience lower retail prices, better promotion, and selections. However, efficient operators survive and possibly gain share, still pressured on margins. So the high cost operators usually lose their tax advantage excuse. They get exposed on true operating inefficiencies, and they may fail or sell at distress valuations. So why this matters strategically. So this is why 280E relief doesn't necessarily mean automatic profitability. After relief, gross margin discipline still matters, cost accounting accuracy still matters, inventory efficiency matters more, and operational leverage matters more. Tax relief removes a shield that hid weak operations. So even if 280E goes away, competitive markets, especially in cannabis, they tend to pass tax savings on to customers through lower prices, meaning much of the relief gets competed away unless operators have structural cost advantages. So as we're getting closer to the end of the presentation, I really want to focus on what operators should do now. So the things that they should do now is build a business that is profitable before tax relief. So if 280E goes away, that becomes upside, but it's not a lifeline. Everything else flows from that. So really operators need to treat cost accounting as a survival tool, not a compliance exercise. So you need to move from bookkeeping for tax filing to true operational cost accounting. So you've got to know your unit economics by SKU, strain, batch, cultivation room or production line, distribution channel. And why that matters is because price competition and price compression exposes real cost structures. Operators who don't know true per unit costs end up selling below contribution margin, expanding volume while losing cash. So the future proof effect works. It works well under 280E, and post 280E, it becomes the foundation for pricing discipline. So also you need to optimize your cost of goods sold or COGS now, not just after 280E. So you need to tighten your COGS classifications under what I mentioned earlier in the presentation, IRC 471. So labor allocation accuracy, depreciation inclusion, facilities and indirect production costs. So you need clean WIP and finished goods roll forwards monthly. And this is real cash flow relief today. Many operators leave between 5 and 50% of allowable COGS on the table. So fixing this does not require waiting on Congress. If 280E remains, you have lower effective tax burden. If 280E disappears, cleaner financials, better margins, higher valuations. So you really need to build margin discipline before prices fall further. So implement floor pricing based on variable costs, contribution margin, cash burn tolerance, and kill SKUs that look profitable at gross margin, but they actually destroy cash after overhead. So really, price compression is rarely reversible. Operators who chase volume usually accelerate failure, and the strong operators survive price wars, while the weak operators will exit because they'll become less competitive later on. So get your financials exit ready, even if you don't have an exit that's planned. So your monthly close discipline, inventory counts that actually tie, COGS methodologies documented, owner add backs clearly separated. So distressed M&A is accelerating. Buyers discount messy books more than high tax rates. So clean financials equals better optionality for you as an operator. So this works well, whether you sell, you recapitalize, you refinance, you just survive longer than competitors. And you should assume that capital will stay expensive and scarce at least for a while. So run your forecasts assuming no new equity, no cheap debt, and slower collections. Focus on inventory turns, payables discipline, labor efficiency, and even with tax relief, capital markets may not reopen fast. Lenders still hate volatility. So cash discipline beats tax planning in stressed markets. Operators who control cash control their destiny. And finally, reframe 280 relief as a test and not a gift. So if 280E goes away, prices will fall faster than your tax bill. So the winners won't be the ones who waited, it'll be the ones who fixed operations first. So let me close with some perspective. This executive order represents the most credible and substantive federal movement on cannabis policy that this industry has ever seen. It's not symbolic, it's not speculative. This is grounded in science, backed by real political will, and aligned with a clearly defined regulatory process. The scientific foundation is solid. HHS, FDA, and DEA analysis has already occurred. The political commitment is real. This did not happen accidentally or casually, and the regulatory pathway is clear. We know what steps come next, even if we don't control how fast they move. That said, this is not the finish line. The executive order is better understood as the acceleration of an existing process, not the creation of a brand new legal framework. There are still months, at least months, of administrative procedures still ahead, potential legal challenges, rulemaking requirements, and very careful implementation steps that must be followed. This is where expectations matter. Those who plan carefully will benefit. Those who assume headlines equal law will be disappointed. The opportunity here is structural, not short term. This is not a flip the switch moment. It's a reshaping of the operating environment that rewards disciplined operators over time. So let me just summarize the key realities. The executive order accelerates an existing federal process. It does not instantly legalize cannabis or override existing statutes. Tax relief is likely real and material. So elimination of 280E is probable if Schedule 3 is finalized, but it will almost certainly be prospective only, absent an act by Congress. Schedule 3 is necessary. It's required for tax relief, expanded research access, and incremental banking improvements, but it is not sufficient to solve pricing, pressure, capital constraints, or operational inefficiencies. So, and again, execution risk remains. So legal challenges, procedural delays, and implementation complexity can still affect timing and outcomes. So the takeaway is this: treat this moment as a structural shift, not a short-term catalyst. Build your business assuming discipline, documentation, and execution still matter, because they do. If you do that, this executive order becomes an advantage, not a distraction. Thank you for listening to this presentation today. I think it accomplished its goal in explaining what the executive order actually does, what it does not do, how the Schedule 3 process really works, and what the most likely implications are for taxation, banking, insurance, hemp, and cannabis operators. The goal, like I said before, was clarity and not hype. So if you have any questions or would like to discuss your specific situation, please do not hesitate to contact me at david@proactivetaxplanners.com, or you can go to my YouTube channel to check out other cannabis related presentations. Thank you again and have a nice day.